How are you? My name is Candida Steel, and I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I've been with the program for about 20 years. I hope you enjoy it as much as I have. And Ben?
Sure. My name is Ben Glickman. I'm a supervising deputy attorney general with the state of California. Far more interestingly than that, I'm an alumnus of this program and was lucky enough to be on a national championship team from California 25 years ago now.
And I'm Marcia Holland. I'm in Missoula, Montana, but I was a career public defender in Alaska for my legal career. I now teach at the law school here in Missoula. And I've also been involved with the program for about as long as my fellow judges. So I'm so glad to see you all here. That is just great.
And if you'd introduce yourselves, please, and your teacher.
Good afternoon. We are Unit 3 from Amador Valley High School, representing the Golden State of California. My name is Gloria Xie, and we'd like to thank you for listening to our testimony today.
Hi, my name is Jennifer May.
Good afternoon, or good noon. My name is Benjamin Zeng, and once again, we'd like to thank you for listening to our testimony today. We'd also like to thank our coach, Ms. Sklar, as well as our timer.
Great. Well, welcome, and I'll read the question for all of you. And just to note, I'm in Annapolis, so it's way into the afternoon for me. So you're just getting to noon now. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between the two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? You may begin.
The history of America is fraught with the fight for women's rights. The 19th Amendment, ratified in 1920, gave women the right to vote. The Equal Rights Amendment, first proposed in 1923, would guarantee legal equality regardless of sex. However, despite these legal proposals to guarantee equality of sex, there would not be true equality unless societal perception is shifted.
The 19th Amendment and the Equal Rights Amendment, or the ERA, both sought to remedy gender inequality, but addressed them in different ways, with the former targeting voting equality and the latter legal equality. The 1993 Yale Law Review argues that the impact of the 19th Amendment was limited to the voting booth, and women still suffered huge inequalities in political, economic, and social spheres. When the ERA was introduced, there were more than 300 laws that prevented equality in economic opportunity and education. The ERA, if ratified, would nullify these laws and ensure that, at least legally, men and women are equal.
However, solving gender inequality is much more difficult than simply ratifying amendments because societal perception needs to shift as well. Both amendments had an unexpected source of opposition: women themselves. According to a 2013 Boston University Law Review, female anti-suffragists argued that letting women vote would draw away from their highest responsibility, motherhood. Meanwhile, the ERA was notably opposed by conservative activist Phyllis Schlafly, who mobilized women in the 1970s to advocate for the preservation of domestic spheres. These oppositions reveal a deeper societal belief that biological differences lead to innate social inequalities between men and women.
While the 19th Amendment gave women the right to vote in the United States, the effects did not guarantee political equality. In Hoyt v. Florida of 1961, the Supreme Court unanimously ruled that exempting women from juries was constitutional. Jury duty, like other political duties, were deemed a burden on women, not a civic duty to fulfill. Although the 19th Amendment was ratified to provide some semblance of political equality, women were still not given the same political opportunities as men.
Around the world, the 19th Amendment itself had minimal impact in other countries, but the fight for it influenced other movements in history. UCLA history professor Catherine Marino argues that the fight for women's suffrage in the United States has inspired global movements for immigrant, racial, and feminist justice. Although no constitutions directly cite the 19th Amendment as their inspiration for having these provisions, the transnational legacies of the American suffrage movement are seen in movements around the globe.
To remedy gender inequality, states have ratified their own equal rights amendments. These allow them to make private entities also abide by its provisions, which gives them an advantage over the federally proposed ERA. In Pepper v. Princeton University Board of Trustees, 1978, the New Jersey Supreme Court ruled that the female plaintiff was denied the same employment opportunities as males under New Jersey's ERA. State ERAs, therefore, expand protections against sex discrimination beyond the public sector, spurring the movement towards gender inequality in society in an effort to reach the national level.
However, state ERAs do not have the same power as a federal enforcement of equality. For example, Title IX prohibits discrimination based on gender in any programs that receive federal funding and has been broadened to protect against sexual harassment. In JK v. Arizona Board of Regents 2008, Arizona State University was forced by the federal government under Title IX to investigate incidents of sexual harassment and assault. Arizona, which doesn't have an ERA like 23 other states, does not have these protections. A federal enforcement would have more power to guarantee gender equality in every state.
Despite existing legislation regarding gender inequality, we believe that the Equal Rights Amendment is necessary and should be reproposed to include gender and ratified at the national level. However, true equality will not exist unless societal perceptions are changed. Thank you.
Thank you. You can put your notes aside and
So I'd like
with questioning.
follow up with what you were just talking about. Because the Equal Rights Amendment, as it was proposed and as it was being looked at back in the 70s, there was concern that the language of Section 1 and Section 2 in particular presented big problems. Have you found a model, perhaps among the state ERA provisions, that would serve, if we were able to start over again, that would serve as the best model to be reproposed in Congress?
I actually believe that the wording of our Equal Rights Amendment, while my biggest concern is that it is too binary, I think that it's also too broad of a provision. And in fact, I think we should look at Article 1, Section 8 of the California Constitution, which specifies explicit areas in which equal rights must be enforced.
Thank you.
So I guess I'm a little troubled. Why do we need the 19th, or in particular the ERA? We've already got the Equal Protection Clause in the 14th Amendment. Why isn't that enough?
I believe that the ERA is necessary because it would help shift societal perceptions and push the United States towards greater equality. According to Cambridge professor of social science Bo Rothstein, the greatest reason for inequality in our society is because governments fail to create legislation that push our society towards that direction. Legislation like the ERA would help to move America in that direction, in which equality is not only guaranteed on a legal level, but also on a societal level.
Additionally, currently under the 14th Amendment's Equal Protection Clause, sex is a suspect class under intermediate scrutiny. An ERA, according to Dartmouth government professor Lisa Valdez, would raise sex equality to a fundamental right and increase sex to strict scrutiny. It's also important to note that the primary author of the 14th Amendment, John Bingham, did not have women's interests in mind when he wrote it. According to a speech in his the 39th Congressional Globe, he was concerned about states and their relation to the federal government and had absolutely no intention of including women in the 14th Amendment.
You're muted.
I'm sorry, could you repeat the question?
Yeah.
Oh, sorry.
Virginia became the 38th state to pass the ERA in January 2020. Do you think the archivist should register this new amendment?
I do not believe so. The ERA, as it stands right now, has not been ratified and added because in Dillon v. Glass 1921, Congress said that a sunset clause is constitutional. And since the sunset clause for the ERA is already 20 years past, the ERA is, according to this case by the Supreme Court, invalid.
Thanks.
However,
You go.
I believe that an alternate should be proposed today, and if it were to be proposed today, I believe that it would garner a lot of support and possibly enough to be passed. Today, 26 states have their own equal rights amendments, and 2 more have them passed through one house, waiting to be passed through their second house. As a result, I think that the ERA is really garnering its support within our societal perceptions, and if we propose, would have enough support to pass today.
So on a slightly different note, if you can identify some of the arguments, both pro and con, back when the ERA discussions were really raging in the 1970s, and looking at those concerns through the lens of 2020, for example, gender neutral bathrooms was a concern back then. Can you identify some of the arguments on each side and whether or not they still exist, given the, the changes that have come societally?
So one of the arguments that Phyllis Schlafly relied on was that an equal rights amendment would force women to register for the draft. And this is currently still an issue today. However, I believe that women should be allowed to. In fact, in February 2019, in the Southern District of Texas, U.S. District Judge Gray Miller held that an all-male draft violates existing rights against sex discrimination under the 14th Amendment. Having women register for the draft, therefore under the ERA, I think would not be something to hold back from an ERA, but instead something to look forward to.
Additionally, one of the arguments that Phyllis Schlafly had was that in divorce courts, child custody battles, then it would be biased against the mother if the Equal Rights Amendment were ratified and passed. However, a Harvard Law Review in 1980 found that in cases of divorce courts or child custody battles, single parent custody is actually extremely harmful to both the child and the family because it makes the children emotionally detached from one parent, and it gives an undue economic burden on the parent that has custody. So an equal rights amendment would actually be beneficial in all cases.
I actually believe that there are continuing developments today that have shifted the arguments of the ERA. This could be seen in the case of parental time off work when having a child or adopting a child. A 2012 Department of Labor study found that fewer employees offered paid parental leave for men than for women, and also that fewer men reported receiving paid parental leave. May I finish my thought?
Yes.
Only 13% of men who took parental leave received a pay compared to 25% of women, with many men receiving less than 10 days off of work. Thank you.
Thank you. Thank you very much. Excellent job.
And did you want to have comments first?
Oh, sure. So nice job. Congratulations. Yeah, so I thought you guys did a very nice job, not surprisingly at this stage. The prepared remarks answered all parts of the question. I thought that your discussion of the advantages and disadvantages of states doing an ERA, I thought that was very good. You talked about how states can be broader than the federal government could be, but at the same time, they're not going to have the same, nationwide impact as the feds might. So I thought that discussion was very good. On the Q&A, I thought you guys, you were obviously responsive to the questions. You had good supporting evidence, had clearly spent time with the material and done the research. We're able to get very specific with relevant cases or constitutional provisions. So I don't really have much in the way of constructive criticism to suggest. I just wish we had more time, and congratulations.
Thank you.
Thank
I'll
you.
echo what Ben said. One of the things that impressed me is your, I guess, frank conversation about how the passage of the 19th Amendment didn't really have a ground-shaking effect on the rest of the world. We were a little behind there instead. That's a really good observation to make. I appreciated that when you talked about the 14th Amendment, the whole, you've done your research, that was not intended to give women any rights at all. I think that's a really important thing to bring out. And when I was asking about the pros and cons that were being discussed back in the day, you talked about the draft. And one thing I thought you might mention is, in the background back then, there was a very unpopular war, the Vietnam War going on. And so there were lots of people who didn't even want men to be draft eligible. So, but I think you caught the essence of, the pros and cons back then and why they're just not as viable these days. So I appreciate that thoughtfulness. Good job.
Thank you.
Thank you.
Great. I very much appreciated your presentation. I thought it was excellent, and I have stars in 5 or 6 different places here. I appreciated your response about sunset clauses. Hoyt and jury duty was excellent, but not only did you mention a point, but you always gave a good supporting reason for why you had arrived at that decision, and you did a really nice job of showing us that. I appreciated the reference to the Texas judge's decision on draft, and at the end, the custody issues were very interesting. I think you did a really lovely, thoughtful job, and I hope you've really enjoyed doing this. I certainly have enjoyed listening. And I hope that this experience will keep a place in your heart all your life. It certainly is a highlight of my life to participate in this program. But I hope it's even more than just being proud of how well you've done in preparing and making a presentation. I hope it inspires you to go on to perhaps participate in politics or in representing the rest of us, or being a lawyer or a judge, or I got involved in this program 20 years ago when my cousin participated and was with the Colorado team and did Unit 1, and he now has gotten himself a PhD from Oxford. So this may be a nice way to launch yourselves into your future careers. You certainly know more than anyone in my constitutional law class knew when I was in law school. And so it's been a real pleasure listening to all of you, and I hope it inspires you and keeps you warm all your lives. It's been a pleasure listening to you.
Thank you.